Thank you for taking the time to join the Gutmann and Bogart webinar series in regards to your workforce and COVID-19. Before we get started, we do have a disclaimer to go over, and this communication is not intended to provide any legal advice or opinion on any individual situation and should not be relied on to determine insurance coverage or lack thereof as relates to coronavirus. Insurance forms and endorsements vary based on the insurance company, changes in addition dates, regulations, court decisions, and state jurisdiction. The information is based on review of insurance coverages, sources we deem to be reliable, and communications we have received from insurance companies and other resources. We make no representation or warranty as to the accuracy of information as applied to individual cases. Without further ado, I'd like to introduce our presenter today, Tammy Daniels. Tammy will be focused on workers' compensation claims and how COVID-19 impacts workers' compensation claims. Tammy has 30+ years experience in the industry. She is an accredited self-insurance plans professional. She's a workers' comp claims professional. She is a certified professional in fraud identification, and she's also a fraud instructor for insurance professionals. Without further ado, it's Tammy Daniels.
Thank you, Trey. Thank you, everybody, for attending today's webinar regarding COVID-19 and how it relates to your workers' compensation claims workforce. As we get started, I want to present to you a refresher for all of our clientele. This informational, it tells you a little bit about, reminds you of who your broker partner is. Been in business for more than 30 years. We're headquartered in Orange County. We have affiliate offices throughout California. We're proud of the fact that we are recognized as the top 100 insurance brokers, as well as considered to be the best independent agency to work for by the Insurance Journal. By the end of today's webinar, we hope you will feel informed about the following topics. Some highlights are: can an employee file a workers' compensation claim if they believe they contracted COVID-19 while at work? Can your employees still receive medical care for their work-related injury during this crisis? And what happens with some of the pending litigation that predates the coronavirus, some of those pending hearings or deposition? And finally, if there is a work-related COVID-19 claim, how will that impact your experience modification rate? When we get to the end of the webinar, we'll have a question and answer session. And if you have questions, I would encourage you to use the chat feature that you see on the dashboard. And as long as time allows for it, we will be happy to answer your questions. Okay, first question: how will COVID-19 be treated within the California workers' compensation system? COVID-19 is a novel, meaning new, strain of coronavirus. COVID is actually an acronym broken down. CO stands for corona, the VI stands for virus, and D is disease, COVID. And the first case occurred in calendar year 2019, and that's why you have COVID-19. As it relates to workers' compensation, it is new. And so because it is new, there is not yet a definitive statutory presumption or any workers' compensation case law that specifically governs its infections. We do expect that there's going to be a presumption that will be put in place, and it will include the COVID-19. Also, it is expected that workers' compensation laws surrounding COVID-19 will be developing rapidly, and we believe this will come as workers contract the virus in the workplace. As you may know, the symptoms of COVID-19 are similar to pneumonia in that they have fever, sore throat, coughing, and other respiratory complications. Because of this, it is speculated that COVID-19 would be treated similar to pneumonia within the work comp system. In addition, COVID-19 pandemic may also have some compensable consequences that don't necessarily mimic the typical COVID symptoms. And so we've included that they would be considered what they call a compensable consequence to COVID-19. We've listed psychological trauma, weakened immune system. There's possibly more. So in addition to regular medical treatment for COVID-19, there would be increased benefits for these conditions if COVID-19 were to aggravate them, whether pre-existing or not. What all employers want to know is, can your employees file a workers' compensation claim if they believe they contracted COVID-19 while at work? Yes, they can. And with any work injury, an investigation would be required to gather evidence that the virus was actually contracted while in the course of their employment. We believe that it would be a difficult investigation to prove the moment and exact method of transmission for COVID-19, as this is a global pandemic, which means it can be transmitted by anyone and anywhere. We predict the highest frequency of work-related transmission will occur amongst those essential workers. For purposes of this webinar, we identify essential workers as anyone who leaves the home to work to attend a job site or a place of employment. Currently, there are some presumptions in workers' compensation for first responders and healthcare workers. We fully expect that that presumption will be expanded to include essential workers as it relates to COVID-19. This is something we are keeping our eye on, as it is continuing to be an evolving issue. It is important to you as an employer to know, when do you have a duty to provide a claim form or DWC-1 form? As it relates to COVID-19, when should you provide a claim form? Is when you're essential worker after testing positive for COVID-19. And a positive test or positive finding can occur presumptively, as not all treating physicians are performing or recommending testing. What does that mean? It means if you've sent your employee home to follow up with their private doctor, and their personal doctor tells them that based upon their symptomology that treating doctor believes that they have COVID-19, that would be a presumptive diagnosis. And if they came to you and said, my doctor says I have COVID-19, I believe that I contracted this at work, you would at that point have the duty to provide a claim form. This is also an evolving issue as to who is eligible, who is presumptive, and when to provide the claim form. When to provide the claim form for COVID-19 is different than when to provide a claim form for injuries other than COVID-19. It's important to note that injuries other than COVID-19, the duty for you as the employer to provide the claim form arises at the time that your employee states that they were injured at work. At any time that you have questions regarding this, we would invite you to contact the Wood, Gutmann, and Bogart Claims Department or your broker for further guidance. How can an employee prove their exposure to COVID-19 is work-related? First thing, I think it's important to communicate with your employees and direct them to notify their supervisor immediately if they have been exposed to or test positive for COVID-19. For those employees who generally wouldn't be considered high risk, such as grocery store workers and food service providers, for example, the person filing a claim would have to provide a statement and any available evidence regarding exposure. Some typical questions that you may ask your employee if they report a work-related COVID-19 exposure, and also would be asked by the adjuster when and if you had to report a claim, is listed here. How were you exposed to the virus? When did the exposure most likely occur? How long and how frequent were you exposed? All of these will help in the investigation. If after the investigation, it is determined that the COVID-19 exposure occurred to your employee while they're in the course of their employment, what benefits would they be eligible to receive? I've listed a few here. They would be eligible to receive reimbursement for medical care and continuing medical treatment, disability in the form of lost wages, and any potential long-term care as a result of the injury. Our recommendation is that all potential work-related COVID-19 claims be submitted to the carrier, and they will be investigated properly. Most carriers are implementing their infectious disease claim handling protocols to respond to COVID-19 claim reports. How does this impact employees and employers with current workers' compensation cases that occurred before the COVID-19 crisis? It's been very disruptive. Appearances at the Work Comp Appeals Board are being rescheduled due to social distancing requirements and a stay-at-home order. There is an exception of expedited hearings. Expedited hearings can occur. They're very limited based issues. Those are occurring. Mandatory settlement conferences are all off calendar through May. Depositions are currently being rescheduled. Those are typically take place in person. If medical exams are occurring, more than likely they are occurring via telemedicine. Medical legal appointments such as agreed medical evaluations or qualified medical evaluations are also rescheduled. Trials that were set to take place, lien conferences that were set to take place are continued until further notice. No in-person hearings will take place. The Work Comp Appeals Board processes and procedures are being updated week to week. Many of our clients have employees who are off work and require medical attention. They're asking what will happen to those current active cases. Medical treatment is important to occur on every injured worker. Telemedicine has taken the place of an in-person medical evaluation. This can occur via video conferencing or calling. Industrial clinics, they've gone to a hybrid situation most, in that if you have a new injury, they are seeing that patient face to face. Once that they establish that employee as a patient, they then would convert that employee or patient to a telemedicine platform. Not all medical legal services are essential. For one, dental. So if you have a claim that involves dentistry, the treatment would be put on hold for now. Medical legal evaluations, AME and QME, require face-to-face evaluations per the rules and regs. Medical legal evaluations are required to take place within a certain time period. We fully anticipate that there will be some more lax statutes in place during this COVID pandemic. I expect delays will occur. Additionally, all elective non-emergency surgeries have been canceled, and most do not have a future date scheduled. Once everything reopens, those surgeries would get put back in place. Let's discuss for employers who have essential workers working at your location or job site. What can you do as an employer to protect your workplace as well as your workforce? You can actually institute processes where you are allowed to, per the EEOC, ask your employees if when they enter the workplace, if they have COVID-19, have they been tested for COVID-19, or are they experiencing any symptoms associated with COVID-19? Another screening process that's now allowed, and this is new, specific to COVID-19, is that employers may also check the temperatures of their employees entering the workplace. If you have an employee who refuses to answer the questions or refuses to submit to a temperature check, the employer can refuse to permit him or her to enter the workplace. I've provided the link here, the EEOC link, about this pandemic, and you can refer to that for further information. You know, the coronavirus pandemic has reshaped workplaces and work practices in the space of just a few weeks. Employers must quickly adapt to new safety concerns, new workplace injury claims, and new processes while managing through a crisis that we have never experienced. I feel for you out there. Something that is different for teleworkers versus workers that come to your location, in that you're allowed to ask the employee questions about COVID-19. It is different for teleworkers. You may not, as an employer, ask a teleworker if they have COVID-19 or symptoms associated with COVID-19, or whether they've even been tested for COVID-19. Your source is also the EEOC. The link is provided there for you. Employers want to know, what happens to my XMOD if I have a work-related COVID-19 claim? And the WCIRB is actually reviewing a proposal to exclude claims with a COVID-19 diagnosis, and that dates back to December 1st, 2019. Why would the WCIRB do this? Is because the occurrence of COVID-19 workers' compensation claims are unlikely to be a strong predictor of future claims cost. Therefore, it would not meet the intended goal of the experience rating. This is the changing issue that we'll also continue to keep our eyes on and provide you updates from our resource page at Wood, Gutmann, and Bogart. Okay, now comes the end, and we wanted to provide you this brief, concise, and provide you with practical information. Let's see what questions that we have, and I will provide you some answers. Okay, going to the chat, it looks like we have a couple of questions. The first question, is telemedicine done in Spanish? Yes, telemedicine is conducted in Spanish. It's allowable for an interpreter to be present on the phone during a telemedicine call. It's not like at a deposition or a medical legal evaluation where an interpreter has to be in person. So yes, just because your employee's first language is not English, they could still see the doctor with an interpreter. Second question, can I get a copy of the presentation emailed to me? Yes, it's my understanding we have all registrants' email address, and yes, we can send you a copy, and also this recording and the slide deck will be available on the Wood, Gutmann, and Bogart resource page.
Thank you, Tammy. We appreciate you providing insight for our clients. For our webinar for workers' compensation claims during COVID-19. Again, we invite you to reach out to your broker or Tammy, her contact is there, at any time to set up a one-on-one call. We are available for you, and we look forward to hearing from you. Thank you.